It is 12 o'clock p.m., Friday, July 12th, 2024, and we are about to start a webinar. We're live broadcasting from the Sacramento County Law Library in Sacramento, California, and we're going to wait a few minutes because we have some more people joining us. So we'll wait about 2 or 3 minutes more, and then we will begin. Thank you all for being here. I'm Amina Merritt, staff attorney at Housing and Economic Rights Advocates, short for HERA. HERA is short for that. So, and by the way, HERA also is the Greek word for family, childbirth, and something related to family. So it's a great word. We'll be back shortly. Good afternoon, everyone. We're going to get started. It's about 12:03 right now, and if those who straddle in late, they can just join us. Again, my name is Amina Merritt, and I'm a staff attorney at Housing and Economic Rights Advocates. HERA is short for that title, and we are presenting this webinar. It's the part of the Ask a Lawyer series that is a collaboration between HERA and the Sacramento County Law Library. And so we're presenting one of these every month. And today we're live at the Sacramento County Law Library, where we have a wonderful training center. If anyone ever wants to come to these webinars, there are 10 stations where people can participate live. But please type any questions you may have as we go along into the Q&A box as you listen to this presentation, and those questions will be answered at the end. At the end, you will also be asked to complete a survey, so please do complete it. It helps us get additional funding when we can do that. So one more thing, a disclaimer. Please note that this presentation is for informational purposes only, and it does not create an attorney-client relationship between you, the participants, and either HERA or the County Law Library. And if you need more or additional information or resources, some will be provided at the end of this presentation, and we will give you the contact information for both HERA and the Law Library. So thanks again for being present today. First thing we're going to do is look at some photos of Scum and Slums. A lot of people like the title of this because it accurately describes what some people in California are living in. And these photos show mold in the bathroom and kitchen, mold under the sink, scum under the sink. Here's some photos where the ceiling tile is buckling because of water damage, ceiling to wall water damage here. You can see some structural damage outside this slum building, which shows evidence of mineral deposits outside the apartment building. This one shows evidence of water damage inside, condensation on a window, a two-paneled window that reveals that some moisture may have been leaking in there. And here's some more pictures of some slums. Here you can see how the wall of the building, the bricks are not even, and this slum has missing windows and structural defects, and it's all fenced in because it's probably going to be demolished. So the agenda I would like for us to follow today regarding Scum and Slums, Habitability 101, is for us to go through the laws in California that are related to habitability, to talk about some practical tips that tenants can use for handling habitability issues. And then finally, I'll give you some resources at the end that can help you solve some of your problems with habitability issues. We'll take a little break for water, and then we'll have some Q&A for the rest of the time we have together. And so hopefully we'll have enough time to do all that. The first area we're going to deal with are the California laws related to habitability. And the first one I'd like to talk about is California Civil Code sections 1941 through 1943. And you'll see that these are all of the ones we're going to talk about in order. Health and Safety Code section 17.920, et cetera. The California Mold Protection Act we're going to talk about, and then also the implied warranty of habitability that exists in every agreement in California. So let's start with California Civil Code section 1941.1. That code section specifically states that landlords are required to keep the home habitable. And habitable means safe and fit to live in. And safe and fit is actually defined in code section 1941.1. It says that the home must be habitable or made habitable, regardless of how it looked when the tenant moved in there. This code section also lists all the things that make a dwelling untenantable. And untenantable means the same thing as uninhabitable. Code section 1941.1 lists the things that the landlord must provide and also refers to the health and safety code that we're going to discuss next. So the list of physical things that the landlord must provide under Civil Code section 1941.1 include these: waterproofing, weather protection on the roof or outside walls, unbroken windows and doors with working locks, plumbing or gas in good working order, water capable of running hot and cold separately with proper fixtures and sewage, heat, and unfortunately in California, air conditioning is not required. And this will mean something to all of us today who are experiencing the heat wave that is covering the United States, but mainly here in the West. We are breaking records with triple digits. And so I just want to make a point that housing advocates are currently looking at proposals to make to the legislature because climate change is heating California. And there are places in California where there is no air conditioning currently in apartments, and people are sweltering and having to find ways to provide their own air conditioning. So unfortunately, air conditioning is not something a landlord in California yet is required to provide. The list also includes electrical lighting, wiring, and equipment that complies with the building codes and the electrical codes. So they can't have wires hanging from the lighting outside, and those things have to be in good repair. The grounds need to be free of trash, filth, rubbish, rodents, and vermin. We'll talk about those rodents and vermin inside later. There have to be adequate trash cans and trash receptacles on the property. And the floors, stairs, and railings need to be in good repair. The list goes on. The list also includes working smoke and carbon monoxide detectors, safe fire and emergency exits, a locked mailbox, which is an issue for many people these days, adequate pest control for rodents such as rats and mice, and insects such as roaches and bed bugs. So the landlord must provide adequate pest control. Repairs to prevent and fix health hazards such as fire, lead paint, visible mold, and dampness, as I showed you in the photos at the beginning. This law does not prevent the tenant or the landlord from applying for energy saving programs or monies to repair or replace these systems that the landlord is required to provide. And so the landlord cannot prevent a tenant from signing up for Sacramento Mutual Utility District low cost saving energy programs that may help you repair some things inside your apartment. Additionally, we're on the second law that we want to discuss, and that is the Health and Safety Code. Section 17290.3 defines, and actually, let me just state that this code section is mentioned in section 1941, which we just talked about. And this particular code section actually defines what a substandard building is. And so it says that a substandard building is one that has conditions that endanger the safety and health of tenants or the public. And these conditions include inadequate sanitation, dampness, dilapidation, or improper maintenance, such as I showed in the photos at the beginning. Structural hazards, for example, the stairs or the ceiling are falling down. Faulty insulation, so you're freezing in the winter, you're burning up in the summer. Other fire, health, and safety hazards, for example, mold is a health hazard when children have asthma. And we're going to talk a little bit more about that later too. So health and safety code, that health and safety code section lists all the things that a landlord, that causes a building to be defined as substandard under the law. And that's important because it gives tenants a tool or a hammer with which to correct these situations in their buildings. Next is the California Mold Protection Act, and that is found in this Health and Safety Code section 26147. This was enacted in 2022, and it states that a landlord is only liable for mold. And a lot of people are unhappy to figure this out, that landlords are not generally globally liable for mold. We do have a lot of mold all over California, and HERA gets a lot of calls from tenants about mold infestation. But this particular code section makes it clear that landlords are not strictly liable for mold conditions. They first have to know or have reason to know that the mold, here's the bold language, exceeds permissible exposure limits or poses a health risk. The problem with this statute is California has never defined quote unquote permissible limits. So the mere presence of mold does not mean it's a health threat. And that I like to compare to San Francisco, which has a local ordinance that flat out declares that mold is a public health threat. And when you look at all the information that exists with respect to mold, what it is, how it infests the walls and floors of apartment buildings, and how it grows into the walls and causes health threats for sensitive people, such as children with asthma. It's one of the leading causes of death in children. I'd like to mention that HERA has a specific mold webinar that I do. It's called Dealing with Mold as a Tenant. You can also find that on our YouTube channel that goes more in depth about the problems with mold. But I also want to point out this law, the California Civil Code, section 1102 through 1102.17, that became effective in 2022. And it, in comparison, goes hand in hand with that prior code section 26147, because it also says that all the landlord has to do is give notice of known mold conditions and work with tenants to clean it up if they're advised of the presence of mold. And then also after 2022, tenants renting an apartment are supposed to be given a mold guidebook. Normally, it's seen as an addendum to the lease, and so that guidebook is supposed to be presented at move-in so that the tenant is informed about the mold and how to clean. And this particular code section applies to buildings with 4+ units. And also, in addition to the California Mold Protection Act, this civil code section, the air quality laws may also apply, and those are enforced by the Environmental Protection Agency. I'm going to give you a reference to the EPA at the end of this presentation. I see there is a hand raised, and we are asking that everyone put their question in the chat box, or I will answer all questions at the end. We just want to get through the material first so everyone will have an equal chance to put their question in the chat box. Thank you. So this last section on the law has to do with the implied warranty of habitability. This is what implied means. All the lawyers on the line will know that we use implied a lot in the law. And what it means is something is presumed to be there, even if it's not in writing. And so in California, all lease and rental agreements are understood to have a warranty of habitability. And this means that every landlord who signs a lease is presumed to be warranting to that tenant that the premises are habitable, tenantable, safe, and in good repair, and also that they comply with the building safety and other construction codes. And the reason I emphasize this is because we have talked to tenants around California who live in units that were added on to a duplex or a house, and it doesn't comply. It's what's called an unpermitted unit because it doesn't comply with building, health and safety, and other construction codes. And the person who constructed it didn't get permits from the city to build it. And so arguably no one should be living in it. It's not authorized. And under that situation, the landlord shouldn't even be allowed to collect rent for that type of premise. And so make sure that you're moving into a place that already is habitable. And if not, that you demand it be made habitable prior to moving in. California Civil Code section 1941.3 says that this implied warranty cannot be waived. Waived means given up in writing or otherwise. So if you read your lease before you sign it, and it's telling you the landlord does not give any implied warranty by this agreement, or tenant agrees to waive any habitability claims under this lease, or any language like that, that language is not a legal clause in a lease, and you may want to discuss that with the new landlord. I mean, it may make you seem like a problem tenant because you're asking this question, but there should be no clause in a 2024 California lease or rental agreement that tries to get a tenant to waive their right to a habitable unit. This implied warranty of habitability It's, like I said, implied by law, and it can be enforced by law. And I anticipate that some of you are going to be asking how to enforce it by law. Unfortunately, if the landlord doesn't do it voluntarily, tenants are left to the legal remedies that exist by law, which for some tenants could be a small claims court action for reimbursement of rent. It could be a civil action in superior court, which then gets into the tenant having to pay out for or get an attorney to do it on a contingent fee basis free until you win. But in any event, it can form the basis for a tenant to say, this place was uninhabitable and I should not have been paying rent for it. And it would support a claim of that kind. So the next area we're going to go into, we're right along our timing here, is to talk about some practical tips for tenants based on all of the laws that we just reviewed. Tenants, you are also required to keep the unit safe and clean, and some people don't do that. So tenants can be responsible for damage that they or their guests caused if they don't keep the place in good repair and break things and then don't tell the landlord they broke it and try to leave it that way when they move out, because you will have to have a move out inspection and you could be liable for things that are broken. But tenants do have the right, the legal right, to request repairs for conditions that they identify. And the conditions that the list that is in section 1941.1 and the list that is in the health and safety code. When those conditions exist, the tenant has a legal right to request that the landlord repair those. And tenants do have the right to report health and safety issues to government agencies responsible for enforcement. Those agencies include code enforcement, the public health officer, and I have heard many tenants tell me that someone came out to inspect and they spoke to the governmental official, and the next thing that happened was an angry call from the landlord or property manager asking why they spoke to the governmental official. Well, you have the right to speak to that governmental official. That person is that agency, and the enforcement officer are responsible for enforcing the building code, the health and safety code, the civil code, the conditions of apartments and buildings that are being rented in that city. And so you do have the right to speak to those officials. You do have the right to initiate inspections by calling those people. And as I will tell you in a minute, some of those city agencies have an online complaint process for citizens to complain about substandard buildings and uninhabitable conditions. The landlord cannot retaliate against a tenant for exercising this right. And that is specifically found in California Civil Code section 1942.5, also found in the California Fair Housing Act and the Federal Fair Housing Act. All of those prevent a landlord from retaliating against any tenant that exercises their legal rights. And particularly 1942.5 prohibits that under state law for a tenant exercising the right to request repairs. Some more practical tips: that if conditions are so bad that your health and safety is in danger, you can leave that apartment immediately and be entitled to relocation assistance. Of course, you would be required to notify the landlord that you're leaving because this place is uninhabitable. It's endangering the health and safety of me and my children, for example. I've had tenants who do have a letter from their children's doctor saying that the infestation of mold in their apartment is causing chronic asthma to become excessively worse. And if you have such a letter, you can present that to the landlord. You can request reasonable accommodation, or you can immediately break your lease and say that you need to be assisted to move out of that uninhabitable environment. And you should also ask any code enforcement or public health officer about relocation assistance. If you receive some notice from the code enforcement agency of your city or the public health officer saying that the building has been condemned, or there are conditions that are going to cause you to have to move out because the landlord is in violation of building code or some other code, then you ask about relocation assistance. You ask what you as a tenant are supposed to do when you're paying rent for that place that the public agency has declared to be uninhabitable. But there is a caution, because you have to understand that once you begin withholding rent, it does put you at risk of an eviction action filed by your landlord. The Tenant Protection Act that we have in California, it does say that uh, just cause eviction, one of the reasons for just cause eviction is non-payment of rent. So as soon as a tenant exercises their right to stop paying rent, they do subject themselves to that possibility. And it will be an affirmative defense if you get sued in unlawful detainer that the place was uninhabitable, but you really don't want to have to get to the point of having to defend yourself in an unlawful detainer eviction lawsuit. So that caution is just for you if a tenant intends to employ the repair and deduct process, or if they're going to move out and just completely stop paying rent. So this next slide is going to talk about that repair and deduct remedy. The repair and deduct remedy is allowed by Civil Code Section 1942 and 1942.5. And it specifically says that there are certain requirements before the tenant can employ that remedy. And so as soon as a tenant informs the landlord, either in writing, and actually this statute says in writing or orally, but I like to encourage clients to put that notice to the landlord in writing, because if you ever have to introduce evidence in a court of law that you put the landlord on notice, the best piece of evidence is a document, a letter dated from the tenant to the landlord specifying the exact problems. And the landlord only has 30 days to repair. And if the landlord neglects to repair within 30 days, that is the point at which the tenant has the right to repair and deduct. And just be cautious too. You can't use the repair and deduct remedy to repair damage that you, the tenant or guest, caused. And landlords are not, I made this point earlier, landlords are not allowed to collect rent for units that are substandard, that are uninhabitable, or that violate building health and safety and other, electrical codes and those kind of things. So, there could be an argument that you might be entitled to rent reimbursement or a partial rent reimbursement if your electricity hasn't been working and you've spent 30 days without electricity. Or these are not absurd, because I've had clients tell me that they've lived like that. And so when you don't have the benefit of what your lease says the apartment includes, you potentially should not be paying for that. Here are some more tips. You can find the code enforcement or public health officer for your city or county by going on Google or another internet search and just put in code enforcement. Redwood City, code enforcement, Sacramento, whatever you put in, it should pop right up there with the phone number you can call and or website. And I urge you to go on there. Like I said, some of the cities and counties offer online complaint process. So you can put your complaint right there in a chat box, and the code enforcement officer will hopefully respond to you. I will point out too that I've had numerous people complain that they get no response from code enforcement. They get no response from a public health officer. If that happens, you can potentially go to your city council and put the city council or your particular council person on notice. Hey, you're my council person for this district, and we have a slum in our district, and you need to address that. And some council people will take notice of that. There's also the Board of Supervisors for each county in the 58 counties of California. And so you can possibly go to the Board of Supervisors and point out, take your co-tenants with you and say, hey, we're living in this slum and our landlord refuses to fix it. Can't the county do something about this? We've called code enforcement won't respond. And I'll also mention that the housing advocates in California, we're kind of talking about what code enforcement city officers and county officials are not responding when people call. And so if you have that complaint, we at HERA would love to hear about it, because we are trying to figure out, where the good code enforcement areas are and where they are not. But um, I have found that you can find a good responsive code enforcement officer who will address conditions, and you can get one to issue a report. And the other point about code enforcement is that landlords not only can be cited for conditions that violate codes, but they can also be ordered by code enforcement officers to repair things within a certain time, and they'll come back to make sure it's been repaired. And I know there are people who've experienced that and seen things still not be repaired. And that's why I give you the advice that you should bring your public officials to bear, those that we vote into office and whom we spend our tax dollars with. We should demand that people not be living in uninhabitable buildings. And here are some additional resources for mold. The EPA, Environmental Protection Agency website, has a mold, they have a whole section devoted to mold and everything you need to know to identify and clean mold. It also contains information, training, downloadable images, and educational resources that people can access to understand mold better. And then that same with the CDC, the Center for Disease Control website is here, that contains basic facts about mold and how it affects people's health. And that is where you can go if you'd like to look at the information that the Center for Disease Control gives regarding the connection between mold and various health concerns, particularly asthma in children, and other respiratory problems that are caused by mold. Mold is probably one of the biggest habitability issues that HERA gets called about on a weekly basis. And so it's unfortunate that it's not a liability situation. Both the landlord and tenant have to work to clean it up. And as I said, I have a particular mold workshop dealing with mold as a tenant. You can access that on our YouTube channel. I did that last year, but it's still timely and the law is still current. So finally, the thing I'd like to show you, everything that I just told you is summarized on this sheet that is a Know Your Rights bulletin from the California Attorney General's office. This fact sheet is put out by Attorney General Ron Bonta's office, and it is a really good thumbnail overview of all of the laws we just discussed. And it helps you to know your rights as a California tenant regarding habitability and your right to a safe and well-maintained living situation. And so as it shows you, your landlord has to keep the house habitable. You can't cause damage. You have the right to ask for repair. And so all of this applies, and I would recommend you can go right on the DOJ website and you can print that out and have that at your disposal if you need to know, how to access the law that your landlord should be following. So now we're at the point where we're going to take a 2-minute break. I see that there's another raised hand. So after the 2 minutes, we're going to address the questions and answers that have been put in the chat box. And we're going to answer those live questions for those of you who want to ask your questions. But I want to encourage you to go take a drink of water because we are in a heat wave and we need to rehydrate to stay healthy. And I particularly, because I suffer some health conditions. So let's go hydrate, take a short break, and we'll come back for some question and answer. Thank you. Okay, we're back. And actually, we have a lot of good questions in this chat box. So I'm just going to go through them one at a time. Hopefully, I'll get to answer all of them. And as I expected, we have quite a few that are related to mold. One person asks, what are our residents' rights when there is mold present? Management is aware, they're aware, but will not assist with the issue. I just went over what should be done in that situation. And, if the landlord is ignoring the mold issue, perhaps perhaps the repair and deduct remedy would be appropriate for that. But you may need to call code enforcement and get code enforcement out there to look at the mold and issue a report. They can order the landlord to ameliorate the mold. I will point out that mold remediation, that's the term. If you Google mold remediation, you're going to get a bunch of companies in California. That's all they do. And I know many of you have seen the public uh, the commercial on TV, Serve Pro, and there are some other well-known cleanup entities that specifically do mold remediation, because it is not easy to clean mold when it is really infested in walls and flooring and maybe the baseboards and the drywall of the building. And so there's also someone who asks about work being done where the walls are open and they're possibly being exposed to the mold spores that are coming out of the wall while it's open. Tenants should not be forced to live in those kind of conditions if mold remediation is being conducted. And the proper mold remediation expert will tell you that the people need to vacate the premises, and the landlord, you're paying rent for that premises, so the rent that you pay needs to be given to you to go to a hotel for the time that rent is being paid, and you can't live in that unit. So the landlord needs to pay for you to live in a comparable place while your unit is being repaired. If the landlord wants to do major mold remediation, I will make this one caution, that under the Tenant Protection Act, substantial repair is just cause to evict people. And so this puts tenants in sort of a catch-22 when the mold is so bad in the building that it does require substantial repair, and therefore possibly gives the landlord just cause to evict everyone in the building, because they're going to rip out all the walls and the drywall and repair the entire thing. And so everyone's going to need to leave, and it's going to take more than 30 days, which is what is required under the Tenant Protection Act for there to be just cause for substantial repair eviction. And so, it can get you in a situation where you get yourself evicted because the place has to be substantially repaired. But you do have the right to come back when it's repaired, and arguably at the same rent, because the landlord should have made it habitable before you moved in there. And if they knew there was mold, they should have cleaned it up to make it habitable. So I hope that gave you some guidance. Call code enforcement. Do your best to get someone out there, because as I just stated, the California Mold Protection Act does require a public official to verify that there is visible black mold, visible green mold, visible whatever it is, and the degree to which it poses a health and safety risk in that particular unit or the entire building. There's a question here. Can a tenant refuse to pay rent due to refusal to repair the mold issue, especially if there are children in the home? The mold is constantly growing in the bedroom windows. I do believe that we answered that question by talking about what to do if you see that condition. Get your public health officer. And for people with children, you should talk to your children's doctor. If your child is suffering from asthma, talk to the doctor about whether it's getting worse and that you believe it's caused by mold spores in your apartment. Doctor can help you get the help that you need to address that, because then it's a health and safety issue for you and your children. There's another question. I hope I answered that for you. There's a question that regarding plumbing. Landlord opened the walls and has this person living in the apartment while plumbing is being conducted. And as I said, depending on what's inside those walls and what kind of substances are emitting after the contractor opens those walls. So I've had clients who there's a warning right on the plastic that the contractor has put up uh, for the room that is being worked on, that says there are toxic materials coming out of those walls that people should not be breathing. And so it's up to you, tenant, to tell your landlord, we can't stay in this apartment while that is happening. We need you to put us up in a hotel. And it's for however long that landlord needs to repair his premises and make it habitable. And so someone did ask, is there a legal timeline for when landlords have to make repairs? As I stated, Civil Code Section 1941.1, et cetera, the landlord has 30 days to repair. And if there's no response to you in 30 days and there are no repairs, that's when you are entitled by Civil Code Section 1942 to employ the repair and deduct. Call a mold remediation. It's expensive. It's probably more than a month of your rent. But if you're going to have to get someone to confirm that your apartment is a health and safety risk, and you can't get code enforcement to come out and do it, then you might want to fight about it by saying, I spent this much money to get a report that shows that this place is uninhabitable and I want my money back. I have a question. I hope that did answer your question. And when it relates to matters of health and safety, Ms. Kelly Nguyen, I'll just point out that again, the health and safety code and the public health officer is a good place to go with health and safety concerns. I have a question from a woman named Stacy Gaines who says, should I recommend my member outreach to speak with legal aid, or would I refer to them to HERA? It depends on, HERA deals with housing and economic issues for clients. Legal aid may sometimes be the people to address if someone has already been sued and they need someone to help them with the lawsuit, then legal aid may be a better place. But a lot of times, the work that we do at HERA does overlap with some of the legal aid service providers in California. We're all on the same page, and we do try to service all of the same clientele. But yes, you can call us, see if it's an issue that HERA should address. And if it's not, we will tell you and we will give you a referral to the appropriate legal assistance that you can get. Teresa Doan says, I have lived in my apartment 30 years, yet the landlord will not replace my carpet. I am sure it's a health hazard, but can't afford to replace it myself. Yeah, I've heard about those grungy carpets. Yeah, 30 years is a really long time. And what I will say is that the thing that it makes me think of is Civil Code Section 1950.5, which relates to security deposits, because that gives us sort of a gauge on the life of a carpet, the life of the paint on the wall, because that code section does not allow landlords to deduct from a security deposit after a tenant moves out to paint, because the law considers paint to have a 2-year life. And so after 2 years, if your landlord has not painted the unit, they can't charge you to go paint it to make it habitable for the next tenant that's going to move in, and they don't have the right to deduct that. And yeah, see, if you think that carpet is a health hazard, again, I would call the public health officer. There's a very good public health officer in Sacramento County, Dr. Casaraj. But some of the counties have really strong public health departments, some do not. But you can ask them to come out and look at the carpet because you think it's a health hazard. But one of the other cautions for tenants, document the condition, take photos and go to those public officials who can help you bring pressure to bear on the negligent landlord. Ruth Cardina says, please send us all the printouts that showed. Oh, thank you. Thank you for your wonderful presentation. I appreciate it, Ms. Cardenas. The PowerPoint for this presentation will be made available, and you can just shoot us an email and ask for it. I think our admin can make it available for you, so you can have the entire PowerPoint presentation from today, as well as that Attorney General Know Your Rights bulletin that was presented at the end of the presentation. Angela Gravalia says, I personally found it challenging obtaining relief in small claims for statutory rent adjustments in Sacramento. The culture of the court appears to be landlord friendly. Well, that's a very good point, Angela. You know, we recently surveyed the small claims courts around California. In fact, I think it was the administrative assistant, Michael Sun, who's assisting with this webinar, surveyed our small claims courts in all of the counties of California. And we did determine that there is not uniformity in the way that the judicial that the bench in small claims court address landlord tenant issues. And I will admit that many of our courts are landlord friendly. It may be an economic thing. It may be where the power lies, but the tenant advocacy, the tenant, what do I want to say? The advocacy on behalf of tenants in California is getting stronger and stronger. And I urge tenants to unify, to assert their rights globally, to join forces with their co-tenants and their neighbors to help keep buildings clean and to make them habitable. There's a good question here. I hope that answered your question, Angela, and you can always call Hera to get a one-on-one consultation with one of our tenant team staff attorneys as well for particular issues. And let me also add that you may have to go, to the next level. Small claims court is no attorneys, and the next level up is the superior court. And if you can find an attorney who believes your habitability issue is so bad that it needs to be a suit, they would take it on a contingent fee basis and recover the costs at the end of the lawsuit when they win. That's contingent fee representation. I hope that answered your question. The next question, what can a tenant do if the landlord consistently refuses to make repairs while also repeatedly trying to raise rent, followed by a failed attempt to evict under the Ellis Act? Wow, that question has several legal issues just in that one sentence, because Ellis Act is not something we were talking about today. Eviction under Ellis Act is a just cause eviction. I'm not going to really answer that question right now, but if the landlord is consistently refusing to make repairs, and let's see, what remedies are available? Landlord consistently waits long periods before cashing the rent check and does not keep the tenant informed of material changes such as change of address, change of a. Yeah, this Ted Hirons, I'm sorry, it sounds like you have a bad landlord. It sounds like you have a landlord. Now, there is always a legal issue regarding the raising of rent. And right now, effective July 1st, 2024, SB 567 is in place, which is the modified and new form of the Tenant Protection Act from 2019. And now that statute only allows every landlord in California to raise the rent 10% or less, or 5% plus the average median income for that area. So raising of rent is important under SB 567 to make sure it's the right amount. And then if, it sounds like maybe Ted is talking about suffering retaliation because he did not get evicted when the landlord made a faulty attempt to evict him. And that sounds like he may be suffering retaliation. I talked earlier about tenants being retaliated against because they exercise their proper legal rights. And see, if Ted was not evicted under Ellis Act, now his landlord is not happy about that. So is now trying to retaliate against him and possibly raising rent beyond what is legally permitted and making you suffer because you got to wait and see if your rent check got. There's nothing you can really do about the landlord not cashing the check and waiting, but the landlord should notify you of material changes such as change of address, change of the management company. Lots of tenants complain that their management company has changed 3 or 4 times in a year. Unfortunately, you have no authority about who your landlord selects as the agent to manage their apartment or who they select as a property manager. So I hope that answered that really complex question, Ted. Next question comes from Miriam Bay, who says, does a resident have to be in good standing with property management to have appliances fixed, such as stove and heating? Well, I wonder what you mean by good standing. No, because the payment of rent is a separate issue from whether that place is habitable. Whatever the landlord promised in the lease, such as a working stove and working heat, that's what they have to maintain for the term of your lease or your rental agreement. The stove must work. The heat, we went over Civil Code Section 1941.1, which includes heat as a requirement under the code. So landlords are legally required to have working heat, a working stove, a working refrigerator. If it's theirs, they have to repair it. I hope that answered your question. Are there ways to have a property inspected for unseen mold at no cost to a low-income resident? That's a pretty good question because I did want to talk a bit. I wanted to make a little point about people who live in public housing and publicly subsidized housing, perhaps Section 8 voucher holders. I want to make a point that although those properties are also subject to the laws we went over, there is another layer of housing standards for people who live in public housing and subsidized housing, because the federal government and Housing and Urban Development, HUD, have housing quality standards that apply to housing that is federally subsidized. And so that's another layer of standards for which the property has to meet those standards in order to be considered habitable. But there are some low-cost energy programs that some of the public utility companies have. I know in Sacramento, SMUD has, low-cost energy to help do some things, but it does not address mold. I would invite you to go on the EPA website or the CDC website and look at what resources they recommend people employ. This mold law applies to everyone in the state of California, not just tenants who live in low-income housing, and it applies to anyone who lives in any housing that they pay rent for in California. I know that mold is a major problem, but tenants do need to work with their property managers, their owner, their landlord, to make it clear how bad the problem is and to elicit their assistance to clean it up. There's a question that says, if the landlord evicts folks for just cause to clean out the mold for 30 days, Does the city pay the landlord for loss of rent? The answer to that is probably no, because the owner of the property is the one who has the legal duty to keep it habitable. And there may be some money that a landlord can access through city funding, funds that homeowners or property owners can access to make repairs. I know that our homeowner team at HERA does assist homeowners with programs that will help them make repairs. I don't have the knowledge about that, but if you want to call HERA for a consultation with our homeowner team and find out what resources there are for grants or monies to help landlords ameliorate mold or do other types of structural and other repairs to make properties habitable. I do believe there are funds that can be accessed to do that, and it wouldn't cover the lost rent, but it actually would help for repairing the property to make it habitable so that tenants are not at risk of health and safety violations. I hope that answered your question. And then the next question is, and also the landlord. I wanted to make sure that I made it clear that if there is just cause substantial repair eviction, the landlord does have to pay for it. It is the landlord's burden, unfortunately, that they're losing the rent for that period of time. If the landlord, someone asks if the landlord will only give 1 day of hotel reimbursement, but it took over a week to repair or replace plumbing, what can be done? Yeah, the landlord is responsible for the entire period, that whole week. And so I would put in writing to let them know, yeah, you owe me that rent for that whole week. And this is what I calculate it to be. And then the next step is small claims court, people's court, where you tell the judge, he only paid me 1 day out of an entire week that I was out, and this is how much he owes me. I'll make a comment. People's court, small claims court, that's what you all see when you're at home during the day watching those judge shows, Judge Judy, Judge Wapner, Judge Walker. I can't even name all of them. That you notice that those shows have no attorneys. That's small claims court. Those are people presenting their case to the judge, showing the judge their documents, and the judge is saying, yes, you owe that person that money. So that's what the process for small claims court. And if you have your documentation in order, the hotel bill that shows it wasn't 1 day, it was 7, that's good evidence. So I hope that answered your question. Another question: mold contractors were told not to disclose any info to me. Well, I don't know. Repairs were done for 5 months, and yet the Santa Clara Law Foundation attorney failed to act on anything other than sending a notice to end the vacancy issued. This actually is a little too detailed for me to read right now on this webinar and answer that question. That sounds like a problem that needs a detailed look and consultation. And if you consulted with Santa Clara Law Foundation, I'm not going to offer an alternative opinion today on this webinar, but I would invite you to call and speak to one of our tenant team attorneys in detail about it and whether it was retaliatory. I see you say retaliatory, and I'm just skimming through some of what you say. I'm sorry I can't answer that detailed question right now, but I do ask you to please call or email HERA to get a detailed consultation. If a tenant's storage unit that was located on the rental property is damaged and infested, how should they seek legal aid? Okay, that's not a habitability question, but it is about damage. It depends on who caused the damage, all those. That is actually also a specific question that is going to require detailed analysis. It depends on what the situation was of the rental property, the unit, how it got damaged, what was it infested with. Yeah, I think that you should talk to legal aid or call HERA or someone for a consultation to determine who, if anyone, is legally responsible for that situation. And then Terry Kane says you interacted with, okay, all the agencies ignored. Again, Tara Kane, I think you need to get a detailed consultation. I see that um, there's clearly bias to protect slumlords. Yeah, I understand exactly what you're saying. Landlords do have more power. They're property owners. Many of these landlords in California, a word about who the landlords are in California. There are many landlords that are large corporate landlords, and those are probably some of the worst. I see that we are over time, and so I'm sorry if I didn't get to your question. There are quite a few more questions here that I did not get to, and so if I did not answer your question, you are welcome to call HERA. Here are the library resources and HERA's resources. Here's our email address. Here's our website address. And this is the number you can call to ask for an appointment with one of our tenant team attorneys to answer your question. Thank you for being here today. And I apologize if your question didn't get answered. Look at some of our YouTube webinars on our YouTube channel that hopefully can also answer your questions. Give us a call and hopefully we can give you the help you need. Have a great day and stay cool, everyone. Thanks.